And welcome back to Life Unrehearsed. Matt Del Vecchio here, specializing in home care, elder care planning, and the senior living industry. Thank you for tuning in on a Sunday afternoon here. A little tribute to the boss on today's show after being here in Montreal this past week. Quite a few people went to the concert. Great show. Hope you're enjoying your Sunday. 4:36 right now. Sunset is officially 4:37 in Montreal. Hey, I want to give a shout out to all the caregivers out there as we head into National Caregivers Week this week in Quebec, and a special shout out to a wonderful organization, non-profit called Abovas. They provide accompaniment services to seniors for things like doctor's appointments and groceries. It's their big fundraiser today at Mundo Trattoria restaurant in Kirkland. In fact, my company's Premier Home Care and Lianas Senior Transition Support are a proud sponsor of this particular event, which includes subsidized spaghetti dinners for dozens and dozens of seniors. So great job, Abovas, and wishing you much success with today's fundraiser. All right, now I'd like to discuss the importance of updating your legal documents as you age. Let's face it, couples get divorced, family conflicts arise, health issues can occur over time, especially cognitive-related diseases such as Alzheimer's. Estate planning and financial issues also change over time. Well, let's bring in Notary Nadia De Riggi to help us out. Maître De Riggi, if I can call you Nadia, welcome to Life Unrehearsed. We're going to try that again. Your mic was just off. Hello, Nadia.
How are you, Matt?
There we go. Now we can hear you. Thank you for coming into studio here. Such an important topic, Nadia. We've had you on the show before. These are tough conversations that we tend to put off a little bit, and I always like bringing it up a couple times a year because it is so important. And, one of the amazing stats that I hear is the fact that over 50% of Canadians do not have a will. It's an amazing stat. Why is it important to have a will?
I think there's so many reasons why it's important. Primarily is that it allows you to maintain control over your affairs. It allows you to make decisions ahead of time regarding your property and your loved ones. Who's going to inherit from you. What percentages will they inherit? Who's going to be the liquidator? So who's going to do sort of the division of the assets? What do you want to do with sentimental items, family heirlooms? So what's important to you and your family, and just making sure that those wishes are respected after you're gone.
It's amazing. Over 50% don't have that will. And you mentioned, we think of, money and finance, but just like you talked about heirlooms, those memories and treasures that you would want to go to specific people. And if you don't have that will, don't put it in the hands of the government to do so. Now, Nadia, there are several different types of wills. Can you go through them with us?
Sure. So according to our civil code, we have 3 types of wills that are recognized. The first type being a holographic will. So that's what you might know as a will that's entirely handwritten and signed and dated by the testator himself, him or herself. The second type of will is a will signed before witnesses. So it's just that. It's a will that can be handwritten or typed, but it's signed in front of 2 witnesses. And then the last is a notarial will. So that's a will in which you will go and see your notary, and you'll give them your wishes, and they'll draft it for you in legal form. So they'll verify the content and the legality of it, and that will be registered with the Chamber of Notaries.
Okay, so this is a bit biased of a question. You are a notary, notarial will, this is what you do. But please explain to me, if I could just write it down on a piece of paper, it's going to cost me a little less. Yeah. So why is there a challenge with the first 2 types, holographic or with witnesses? It seems a little too good to be true. So what happens if you die and you have one of these holographic or witness wills?
Well, I think I'll start by saying it's better than not having a will at all. And I say this to all my clients because I do get that question quite often. But those 2 first forms, so a holographic will and a will signed in front of witnesses, in order to be respected or in order to be validated, will have to be probated. So that means they'll have to be brought before the tribunal to be validated. And so that can take time and it can cost money. And so perhaps it appears that you're paying the notary. And so you say, oh, well, it's cheaper to handwrite my will myself. It's free, when in fact it's not free. Because when you die, then your family will be subject to probate costs, probate times and delays, etc. So it's actually in the long run more costly less effective.
I've been told that as well. So I think important point, just get a will done, write it down. But if you're doing it for cost savings and time reasons, it's really not going to be to your benefit. Start with the will to begin with, but actually notarial wills turn out to be a little less costly and certainly more timely. Now, I'm talking with Notary Nadia De Riggi here on Life Unrehearsed, and I often hear the term living will, Nadia. So what is a living will? Is that another type of will, or explain what that is?
So I'll start by saying that a living will is actually known as a protection mandate in Quebec, but I do hear living will thrown around a lot. So I've learned to interpret what clients mean by what is a living will. A living will is going to touch on what happens to your property and to you as a person if you're not able, if you find yourself in a health situation where you're not able to express your wishes. So where a will determine how your property is distributed after death, a living will or a protection mandate will dictate, okay, well, who's in charge and what happens to me if I'm not able during my lifetime to express myself with regard to administering my property or making my healthcare decisions. So that's the main difference.
Okay, I'm glad you mentioned that. Is a term we often hear is living will. You say it's the equivalent of a protection mandate. On the second half, after traffic, we're going to dig deeper into protection mandates or so-called living wills, as well as powers of attorney. Very important to have. It's while you are alive. Wills is when you die. This is what happens. But a lot of the time, more realistically, what happens if you are now inapt for whatever reason, and now you want to make sure your wishes are adhered to. Now, I'm going to switch gears to advanced medical directive. Some people mix that up for a living will, but what is an advanced medical directive?
So an advanced medical directive is a written instruction. So it's written instructions regarding any preferences that you have for medical care. So it's specific to medical care if you're unable to make decisions for yourself, and it gives doctors guidelines in that emergency situation where you're not able to express your wishes. They will have something in writing that they'll be able to follow. Right now, there's two ways that you can draft advanced medical directives. One is by using the government form that you can find on the RAMQ website.
Great form, by the way. Very easy to access. You could fill it out yourself.
Absolutely. You fill it out yourself. It's mailed to you. It's customized with your Medicare card. And then the second way you can do that is with your notary. So you'll go to see your notary. The content is exactly the same as the government form, but you'll sign that document. It'll be kept with the notary's minutes, so it can't be lost or destroyed or anything like that.
Talking with Notary Nadia De Riggi. One more quick question before we head out to traffic, Nadia, and this is quite common in Quebec. There are common law couples, not necessarily married. They're in a common law relationship. What happens if you're in a common law relationship and you don't have a will?
So I do have a lot of common law couples who come into my office and mistakenly think that they're protected by the law. But what you need to understand is that as a common law couple, you're not protected if one of you passes. And so a will is a really good tool that you could draft and have in your back pocket sort of to protect your spouse and make sure that if something happens to you, your spouse is protected and your family, your loved ones are protected.
All right. Always good to have that, and it makes a lot of sense. Okay, Nadia, if you could stick around here, we got a lot more questions, but first, we're going to hear actually about powers of attorney and that protection mandate, and I'm going to ask you a question about what happens in a situation if you're a couple and you want to sell a property like a house, but one of them has dementia or Alzheimer's. Might not be so easy, so we're going to tackle that one as well. And welcome back to Life Unrehearsed. Matt Del Vecchio here, and I'm talking to Notary Nadia De Riggi about the importance of updating our legal documents, especially as we age. Now, Nadia, just before traffic, some texts are coming in. It's amazing. Lots of questions, and very pleased with the reaction, because it shows that our listeners are genuinely concerned to protect themselves and their loved ones. I want to get right into the difference between a power of attorney and protection mandate.
That's a great question. There's two main points when you're looking at the differences between these two documents. The first is, when is the document going to be used? Because a power of attorney is used upon signature. So you sign that power of attorney, and it can be used right away. And then the second major difference is the scope of responsibilities. So a power of attorney is going to be only for property or specific actions that you'll detail in the document. A mandate can only be used if you're declared incapacitated by the doctor. And that incapacity is then presented before the tribunal. And the scope of responsibilities then becomes a lot larger than just property. We're also talking about healthcare decisions, emergency medical care decisions, sort of who's going to take that step and represent you if you are declared incapacitated officially.
Interesting. I often get this question with our clients as well, because it is a little confusing. So just a quick little summary. Tell me if I'm off base here, but a power of attorney, temporary measure while you're at, but you could have a loved one, a spouse, a child pay bills for you if you're not able to do it. That type of measure. Whereas a protection mandate is if you become inapt. Now you are assigning someone to take care of your affairs, whether it's finance or to person.
It's exactly that. And you have to be able, with a power of attorney, to be able to tell the person what to do for you. So your capacity has to be there.
In all cases, you are assigning someone to do these tasks.
That's right.
All right. And usually a substitute as well. Now, this fancy terminology called homologation. And some think, and I was in this camp as well, hey, in fact, I do have a protection mandate myself. I've put down in case if ever I become inapt, and that could be due to a stroke, it could be due to whatever reasons, Alzheimer's, dementia, what have you. I've assigned a mandatory and a substitute mandatory. I'm good to go, aren't I? Well, in fact, that's not the case. You actually have to have those wishes come to fruition, and that's what homologation is. Is that correct?
Exactly. So homologation is where we're going to apply to the courts to ask for them to enact the document that we have drafted. So if I appoint you as my mandatory and then I'm declared incapacitated, there is a step of homologation where we have to go to the tribunal to prove that I am in fact in need of you to step in at that time, that I am in fact unable to take care of myself. And this is going to be based on medical reports and a psychosocial report from a social worker. So it's always in the interest of protecting the vulnerable person. Is this person really in need of this protection? If so, then great. She signed a mandate. Let's then enact the document by filing it in court. So that's a necessary legal step.
So you're filing it in court, medical assessment, and you're getting a psychosocial assessment through a social worker. We do a lot of those at Lianas, and it takes time. I mean, you've got to get time to do these assessments. And without putting you on the spot, but I'm going to put you on the spot. I mean, how, in your experience lately, how long in Montreal is it taking to get a judgment after you're submitting the assessments?
I mean, that's a trick question. I can't really say. It's going to be subject to the volume of files being treated. I think right now, a couple of months for sure. Before you have a judgment in hand. Obviously, when there are emergency cases, there are emergency measures that can be taken.
Right. And no surprise if it even takes up to 9-10 months. So it's I always like to tell our clients, like, this doesn't happen overnight. And if there's any suspicion or you want to pursue this homologation, better to get things in motion sooner rather than later. Talking with Notary Nadia De Riggi here on Life Unrehearsed. Okay, Nadia, I'm going to give you another scenario and put you on the spot. A couple... they've been in the family home for a long time. They own their house. But over the years, one of the two has been experiencing some cognitive decline and actually got a diagnosis of Alzheimer's, still living in the house, but things have progressively declined and they might have to make a move. So they have to sell the house. Is there an issue with selling the house if one of the two is considered a person who is inapt or has something like dementia or Alzheimer's?
Well, I think whenever you're looking at a case like this, you're going to look carefully at the person who's been diagnosed. And certainly every notary will have their sort of practice. But my first reflex is to say, well, let's maybe speak to the doctor. How far along is the diagnosis? Is this person still apt to make the decision to sell the house? Are they able to understand the decision, the extent of the decision? And if the answer is no, well, then the next step is homologation.
So you can, if the answer is no, I mean, I understand from your perspective, you have to protect the individuals and you cannot sign a deed of sale if one of the two has been considered inapt. So the only choice now is to have that mandate homologated so you can sell that property.
Absolutely. Absolutely.
I have heard, and I don't know if this is true or not, but that's shocking for some couples. They've spent their whole life, the house is paid for, no more mortgage, and they need the income for the next chapter of their lives. And all of a sudden they hear, oh my goodness, I have to homologate this mandate. But it is real, it's happening, and you can't sign that deed of sale. Is there any way to sort of fast track the homologation process to sell a house? Or I've heard that once the file has been created with the court, can you do anything in advance to help that? Or is that you got to wait for that full homologation?
I mean, look, every notary will have, as I mentioned earlier, their own sort of practice. And I think if the file is open and all parties are aware of what's going on, you will find notaries that'll go ahead with the sale. But the answer is truly that you need that homologation. So I think my advice would be to families thinking about selling or, thinking of helping their aging parents look at downsizing. Step number one, along with listing the house, is maybe talking to your notary and getting that homologation started. And then if you have an offer on the table, that's always a great tool for us as legal professionals to use, that we'll present in court to say, look, this is urgent. We need that homologation. So
I think you bring up a very good point, because these things don't happen overnight. So if you're thinking, oh boy, we might have to put this property up for sale, better to get things in motion to be shocked with having to wait 7, 8, 9 months. Talking with Notary Nadia De Riggi here on Life Unrehearsed. We're going to wrap it up real quick with another question. Going to switch gears to the succession process. Nadia, is confusing. And so what happens with succession after the death of a loved one?
Well, every succession is different, but there are a few first steps that apply to everybody. Obviously, step one is the obtaining of the death certificate from the Quebec government. And step two would be having a will search performed. So that's where either yourself as a citizen or your notary will verify the 2 provincial will registries to see if there's a will. And if there is, then where can we get a copy of that? So those are really crucial first steps, and then that will dictate sort of what comes next.
Yeah. All right. Again, going back to the importance of a will. Nadia, we're already out of time here. I want to thank you very much for coming into studio with your 2 lovely children, Sophia and Alessandro. Thanks for listening in here for Mom. Mom did a great job. Way to go, Nadia. How can our listeners get a hold of you?
So my phone is the best way to reach me, 514-484-2788.
All right, that's Nadia De Riggi, prominent notary right here in Montreal. Thanks, Nadia.
Thanks, Matt.
Next week on Life Unrehearsed, I cannot wait for next week's show. You're going to want to be listening in, as I'm going to be talking about a mobile app to test for dementia. I'm going to be reviewing a very controversial law recently passed concerning medical assistance in dying, and a special dedication to our veterans in honor of Remembrance Day. I'm going to have Member of Parliament of Lac St. Louis, Francis Scarpaleggia, and I am going to be talking to this special couple, the McNamara's. She is 102 years old. He is 104 years old. They were both in the Second World War. I'm going to have a live telephone interview with both of them. That's next Sunday on Life Unrehearsed. Special program note, I'm going to be a guest on the Elias Macco show tomorrow morning. I think Justine McIntyre is going to be filling in for Elias. And Justine and I are going to be talking about the recent closure of a fairly good-sized RPA seniors residence in Montreal and the state of the senior living industry. That's going to be Monday, tomorrow, at around just after the 11 o'clock news. Well, that's a wrap. Thank you for tuning in to Life Unrehearsed. As a reminder, for all your inquiries or assistance with home care to help age in place, elder care planning, downsizing in the senior living industry, it'd be my pleasure to help. You can find out more if you look up Lianas Senior Transition Support. That's Lianas, L-I-A-N-A-S, Senior Transition Support. And many thanks to Dimitra Kritidimas and Joey Guzzo, his first live show as an op. Joey, great job. And you were mentored by the one and only Dario De Felice. Both of you, fantastic job today. And Dimitra, thank you very much. You can listen in to Life Unrehearsed here on CJD 800 every Sunday at